Well, hey guys, today on tryapexagent.com, I'm going to do one I believe I haven't covered yet before, and it's land use, legal descriptions, contract law. All right, again, 25 questions. Try and cover them as best I can, see if I can give you some tips. I don't always get all of them right, but that's basically how we go on this. They want you to take it how the test is asking. So um, let's get rolling. A breach of contract is a termination of the contract by the mutual consent of the parties. Financial damage suffered by a party because another party has nullified a contract provision, a lawsuit to force a party to discharge the contract, a failure of a party to perform according to the terms of the contract. Breach of contract is breaking the contract. So I believe it's failure of a party. Yep. Breach of a contract is a failure to perform according to the terms of the agreement. So a breach is something breaking. You don't think breach. So if it's a breach of a contract, it means somebody broke the contract. Failure of a party to perform. Lucas, the seller wants to cancel a contract after learning that Ava, the buyer, misrepresented her financial capabilities. Which legal action may support Lucas in terminating the contract? Forfeiture of the buyer's deposit, a claim for rescission, a claim for punitive damages, specific performance. I think they have a claim for rescission. Yeah, that there's misrepresented, maybe specific performance. Let's look at this. Yeah, claim for rescission. Rescission is a legal remedy that cancels a contract when one party has misrepresented or failed to disclose essential information, thus making the contract voidable. Rescission, so there's people say rescind, and then people think it's like resend that to me, but there's rescind, RESCIND, and that means to basically take it back. Cancels a contract. So there's resend out and then resend spelled a different way, and that's a rescission. So a seller contracts to sell a property that she does not own. The sale contract for this transaction is executable, must be in writing, is void, is illegal yet potentially enforceable. I believe it's just void. The content, promise, or intent of a contract must be lawful. A contract that proposes an illegal act is void. So I have seen where there's a power of attorney or something like that that does help with these, but this is just seller contracts of property does not own. There's a certain fraud that's called when they're trying to sell and they'll get deposits for a house. But a document certifying that a structure complies with the building codes and is ready for use is referred to an inspection report, satisfaction bond, certificate of occupancy, user permit. I believe it's certificate of occupancy. I'm dealing with this now. Building codes ready for use. So this just says, yep, it's ready to go and people can habitate it. Building inspectors inspect a new development or improvement for code compliance. If the work complies, the municipality or county issues a certificate of occupancy, which officially clears the property for occupation and use. So in our town here, we're in a smaller town, more rural. We don't really have occupancy permits, to be honest. We have some other things here, but the occupancy permits are more for like downtown Pittsburgh and some bigger areas. Among other provisions, the Superfund Act, CERCLA, and Superfund Amendment and Reauthorization Act of 1986 provided that large development projects undergo an environmental impact survey immediately after completion of construction. Industrial users of the real estate comply with air quality standards. The EPA would give financial help to homeowners to remedy any hazardous situation resulting from radon, asbestos, lead-based paint. Parties responsible for improper disposal of hazardous waste could be charged for cleanup costs. I don't know this one. This is one that you probably want to know, like the facts before you go in. We'll find out. Look at that. Good. Parties responsible for improper disposal of hazardous waste could be charged for cleanup costs. Something happened around this time, obviously, 1986. And under CERCLA and the Superfund Amendment of 1986, current landowners as well as previous owners of a property may be held liable for environmental violations, even if innocent of the violation. Sellers often carry the greatest exposure, and real estate licensees may be held liable for improper disclosure. Disclose, disclose, disclose. Next question. In the government rectangular survey system, how many sections are found within a township? This I do not know. So township in a rectangular survey system is a 6 mile by 6 mile square containing 36 1 mile square sections. I do remember taking this question in my test. It's just been 10 years actually. So it's been a little while since I actually took my test, but 6 by 6 is what is a rectangular survey. So remember 6 by 6. Obviously 6 by 6 is 36. All right, Charlotte wants to confirm the exact boundary lines of her newly purchased property, which is described as using distances and compass directions beginning at a point of origin. Which method of legal description does this likely represent? So I know this is on the deed, how it says. Meets and bounds, lot and block, subdivision. believe it's lot and block. No, meets and bounds. Let's find out. Here we go. Meets and bounds description identifies boundaries by using measurements and compass directions from initial point, also called the point of beginning. I didn't use lot and block because it actually goes by block numbers, not actually legal description. So government rectangular doesn't sound like, so I kind of did a process of elimination on this. Meets and bounds, I sounded like the best one. So subdivision block didn't sound right. The purpose of the statutes of frauds is to invalidate certain oral contracts, require certain conveyance related contracts to be in writing, nullify oral leases and listing agreements, eliminate fraud in real estate contracts. I believe it's a real estate fraud in real estate. Well, let's see, let's find out. The statutes of frauds requires that certain contracts must be in writing to be enforceable. Real estate contracts that convey an interest in real estate fall in this category, with the exception that a lease of 1 year's duration or less may be oral. That's one I'd probably put for another study. Let's reinforce concept. Sarah verbally agrees to her house for $300,000. They shake hands but don't write anything down. When John tries to enforce the agreement later, it's unenforceable because real estate sales contracts must be in writing. Verbal agreements for property sales are invalid. No court will enforce this verbal agreement. Always get real estate agreements in writing. Yeah, we know that. It just says purpose of the statutes of fraud is just requires contracts to be in writing. It's one I'd probably put to the side to check out again. A prospective home buyer submits a signed offer with a condition that the seller pay for the inspection at closing. The seller disagrees, crosses out the provision, then signs and returns the document to the buyer. At this point, assuming all other contract validity items are in order, the original offer is now an invalid offer, I think, because it's crossed out and then therefore it's changed. Let's find out. Counter offer. So they want them to initial it. So when they send over their initial offer, any changes to it, so if they strike it and then have to put the initials on it, that would be, I guess, a counter. They got that back like that and decided they did not want to initial it, that wouldn't be a counter. By changing any of the terms of an offer, the offeree creates a counter offer, and the original offer is void. See, it's an invalid offer at that point because now it's not, anyways. But it is a counter offer. At this point, the offeree becomes the offeror, and the new offeree gains the right of acceptance. If they accepted, the counteroffer becomes a valid contract provided all other requirements are met. And you usually have to get people to initial under any changes on the contract so that it's not just something struck. You don't know when that was done. So usually there has to be initials by both parties next to them. Sophia's new property was found to have abandoned underground storage tanks left by a former owner. To comply with environmental regulations, which of the following actions might be necessary? We do deal with this in Western Pennsylvania. They did use fuel burning oil for their furnaces and such, and some of them are buried in the front lawn. Which of the following actions might be necessary? Moving or sealing the tanks to prevent contamination, keeping the tanks but posting a warning, inspection of the tanks annually without removal, leasing the tanks to an industrial tenant. I think it's removing or sealing the tanks. Abandoned underground storage tanks can leak hazardous substances and typically must be removed or sealed property to prevent environmental contamination. I think typically what I've seen is they just leave them there. Some of them are still in use. So simulation, Ava has breached a contract to purchase a property. To hold her accountable, the seller decides to sue for damages. What is the seller most likely trying to achieve? Monetary compensation for losses, enforcement of Ava's purchase obligation, transfers ownership to the new buyer, termination of Ava's future contracts. I think she's trying to enforce Ava's purchase obligation. It's trying to get money. The seller may sue for compensatory damages to cover any financial losses incurred as a result of the breach. So I have heard this. If there is a big problem, they can go after you for time and energy, but usually it costs so much, it's not really worth the time. Let's give a real life example on this one. Seller accepts Ava's offer of $300,000 for their phone or for their home. Ava backs out of the contract unexpectedly. Seller lists property, eventually selling for $275,000. Seller sues Ava for $25,000 and damages the difference, plus additional costs like extended mortgage payments, property taxes, utilities, new marketing expenses. This is why sellers typically seek monetary compensation to recover actual financial losses caused by it. It's pretty big there. Something to actually note and listen to there. Mason and Benjamin are under contract for a property sale, but Benjamin is unable to secure financing by the agreed upon deadline. What is the most likely outcome if they cannot renegotiate the terms? Mason must sue for compensatory damages. The contract terminates due to a financial contingency. I think it's terminating due to financial contingency. A financing contingency allows for termination if the buyer cannot secure financing by the deadline without liability. So there are 3 different ways to get out of the contract. Inspection contingency, financing contingency, and the appraisal contingency are typically the ones you can get out of. A legal description of a property is one which accurately identifies the boundaries of the property as distinct from all other properties, accurately describes the location, dimensions, lot, improvements on the property, is accepted by a licensed surveyor is suitable for inclusion in the survey of the property, is written by an attorney licensed to practice real estate law in the state which property is located. Well, the attorney does it. Accurately identifies the boundaries of the property as distinct from all other property. A legal description of real property is one which accurately locates and identifies the boundaries of the subject parcel to a degree acceptable by courts of law in the state where the property is located. The general criterion for the legal description is that it alone provides sufficient data for a surveyor to locate the parcel. Legal description identifies the property as unique and distinct from all other properties. A simulation. The city council is reviewing a proposal for a large-scale retail development near a protected wetland. Community members expressed concerns about possibly environmental harm, which is a likely response by the council. Approve the project and allow construction to begin. Require the developer to conduct an environmental impact study. I'm sure it's that one. Yeah. The council would like environmental impact study to assess potential environmental effects and ensure protection for the sensitive wetland area. We deal with these a lot of times with new home construction. The plans, they usually have to have a wetlands area or an area where, you know, water runoff and such goes. So I have people that want to do certain things because their property does extend in there. A lot of times they won't let you put like a retaining wall and some different things until you get the environmental impact study. So just something to be aware of. That's usually just kind of when you're trying to get into common areas or places that will affect runoff in other areas. So if you have a creek running through your property, I don't think you can just dam it without actually getting the study done. Henry purchased a lot in an area zoned for mixed-use development, which allows for both residential and commercial properties. He is planning to open a coffee shop on the first floor and build residential apartments above. Which of the following best describes how Henry is using the property? Conforming to residential zoning, operating under a conditional zoning exception, using property in alignment with mixed-use zoning, in violation of local building codes. I believe he's using its mixed-use zoning. Mixed-use zoning permits combining residential and commercial activities on a single property, as Henry intends to do so. I did used to own a commercial property, again, apartments upstairs, business on the bottom. What is the one primary purpose of implementing zoning ordinances in a community? To enable flexible development based on market demand, to prevent incompatible land uses from negatively affecting each other, to ensure each property has the same land use rights, to create uniform housing types across the neighborhood. I believe it's prevent incompatible land uses. Yeah. Zoning ordinances are used to separate incompatible land uses, such as an industrial and residential, to preserve community character and quality of life. So they don't just want a brand new residential home on Main Street. You know, they want to keep businesses and such there, in apartments usually. The guardian for a mentally incompetent party enters into an oral contract with another party to buy a trade fixture on behalf of an incompetent party. This contract does not meet validity requirements, is possibly valid and enforceable, must be in writing to be valid, is valid but unenforceable. I believe it's valid and enforceable. Incompetent parties or parties of unsound mind may not enter into enforceable contracts. However, during the period of one's incompetency, a court may appoint a guardian who may act on the incompetent party's behalf with court. So you just, a lot of times they'd want to see a copy of that approval. Power of attorneys, a lot of times they want a copy of the power of attorney. Liam's property is located in an area with strict zoning for single-family homes only. If he wants to run a small bookkeeping business from his home, which of the following will he likely need? This is an exception. A conditional use, a zoning reclassification, an environmental impact assessment, a permit for mixed use development, a conditional use because he's conditionally using it. A conditional use permit may allow for a minor home business in a single family residential area without changing the primary use classification. The essential elements of the meets and bounds system are parallels, baselines, meridians, boundaries, distance, and baselines, reference points, angles, distances, lot numbers, sections, and ranges. Meets and bounds, it's references, points, angles, and distances. A meets and bounds description identifies the boundaries of parcel of real estate using reference points, distances, and angles. The description always identifies an enclosed area by starting an origination point called point of beginning or POB and returning to the POB at the end of the description. Look at a deed if you ever get the chance. They're kind of cool to read. The key consideration in granting a zoning exception known as a special exception is which of the following? Hardship, change of zones, the public interest, the use was legal prior to the new zone creation. Public interest is usually it, because that's what zoning is there for, is for the public interest. The principal forms of exceptions to a conforming use is legal non-conforming use, grandfathered in, variance based on the hardship, and special exception based on public interest. So the public really wants something downtown, it's going to bring in tax money, they can probably get the zoning maybe worked around. What is rescission? The act of modifying the terms of an offer, the act of declaring a contract unenforceable, the act of declaring that a contract is no longer in effect for a given party, the act of withdrawing an offer before it has been accepted. I believe it's this one. Now, again, rescind means you're pulling it back. Parties to a contract may rescind a contract by mutual consent, or a damaged party may rescind the contract unilaterally. So see how it's spelled here differently, rescind. Rescind, like resend an email, is R-E-S-E-N-D. So you're sending out like an email, resend. Rescind is spelled differently and you're pulling it back. Rescission means that you're pulling it back and you're canceling the contract. This act of rescission cancels the contract, returns the parties to the pre-contract condition, including the refunding of any monies already transferred. So rescission just usually means it's null and void. Everybody gets their money back and it's dead. To be valid, a valid contract must reflect a mutual understanding or agreement, use precise wording in a document, not be executable, be created only by an attorney. Use precise wording in a document. Reflect a mutual understanding or agreement. The reason why I clicked on this is because they always want something in writing, and I don't think this, yes it does. I think that's a test question problem. Mutual consent, also known as an offer and acceptance, meeting of minds, require that a contract involve a clear and definite offer and intentional, unqualified acceptance of the offer. And it always has to be in writing, again, working in a precise wording in a document. That's what I thought they were doing, but they just want a mutual understanding or agreement. So mutual. Which of the following is true regarding master planning and zoning? The aggregate of zoning ordinances is the master plan. The master plan eliminates the need for zoning ordinances. The master planning is a county level function. Zoning is limited to the city level. Zoning ordinances are a primary means of keeping land use in harmony with the master plan. It's this one here. The master plan fuses state and regional land use laws with local land use objectives that correspond to the municipality's social and economic conditions. The completed plan becomes the overall guideline for creating and enforcing zones, building codes, and development requirements. Let's get this a little bit more. Master plan. You hear zoning all the time, but not master plan. A city plans to develop a new residential neighborhood. The master plan designates this area for low-density housing. Zoning ordinances then limit building heights to 2-story, require minimum lot sizes. These specific rules ensure that the area develops according to the broader vision. Master plan. I'd like to get my hands on that master plan, I think. Go through, see what it's looking like for your area. All right. A nonprofit organization wants to erect an urgent care facility in a residential zone. Given other favorable circumstances, the local authority may grant permission by allowing a special exception, an illegal non-conforming use, an easement, a license. Let's try a special exception. A special exception grant authorizes a use that is not consistent with the zoning ordinances in a literal sense, yet is clearly beneficial or essential to the public welfare and does not materially impair other uses in the zone. So another thing I've seen in residential areas is little markets, little food markets and stuff I've seen. They allow those sometimes just because they know there's a lot of walking traffic there and it'll obviously benefit the area. So I have seen those sometimes where they've had to actually go and get a special exception for that. Charlotte is under contract to buy a property, but discovers undisclosed structural issues. She wants out of the deal, but the seller insists on completing the sale. Which remedy would most likely allow Charlotte to exit the contract? Specific performance, liquidated damages, rescission, punitive damages. I think it's just a rescission. Undisclosed issues. If there's something undisclosed, they know that they knew about, that's a rescission because you have to disclose it or you can get out of the deal. Basically, it rescinds and cancels the contract. All right. Again, that's the 25 on there. That didn't take too long. What, like 10 minutes, 12 minutes? Anyways, it doesn't take long to do these. I could take these over and over. I probably need 3 or 4 times and I could ace it every single time. Then you're able to walk in your test and usually kill it. So anyways, my name is Sadler Priest. I've been in real estate for about 10 years. Love what I do. If you guys have any questions, real estate related, feel free to reach out. Obviously, comment, like, subscribe, all that beautiful stuff. And I'll see you on the next one. Later.